Imagine you're on a jury for a brutal homicide. The evidence is overwhelming. There is no doubt the defendant killed someone. But then a psychiatrist testifies that at the time of the crime, the defendant was psychotic, hearing voices, disconnected from reality, and the defense asked the jury to return a verdict of not guilty by reason of insanity. Most of us think in very black and white moral terms. If you do something terrible, you should be punished, right? The insanity defense forces us to ask a harder question. When, if ever, is a person so mentally disordered that we can no longer hold them criminally responsible for their actions? Today, I'm going to talk to you about the mentally disordered offenders and the legal implications of pleading not guilty by reason of insanity. This topic sits at the intersection of law and psychology. And I'll explain how the insanity defense actually is, how courts try to measure criminal responsibility. We'll look at some real-world cases, and then we'll explore the ethical debates that make this one of the most controversial doctrines in criminal law. First, what does it mean to be legally insane? It's important to understand that legal insanity is not the same thing as having a mental illness. Many people live with depression, anxiety, bipolar disorder, schizophrenia, and they're still responsible for their actions, and they may never commit crimes at all. Legal insanity is a narrower concept. It's focused specifically on a person's mental state at the time of the offense, so when the crime actually happened. Historically, the most influential test has been the McNaughton rule, which comes from an 1843 English case, so it's very old. Under McNaughton, a defendant can be found not guilty by reason of insanity if, because of a disease of the mind, they either did not know what they were doing or did not know that what they were doing was wrong. In other words, it's basically just a cognitive test. Did the person understand the nature and the wrongfulness of their act? In the 20th century, some jurisdictions adopted a broader approach to the American Law Institute's Model Penal Code. This test still required a mental disease or defect, but asked whether the defendant lacked substantial capacity, either to appreciate the criminality of their conduct or to conform their behavior to the law. That adds a different component. It's not just whether the person could think clearly, but whether they could also control themselves. Today, states have different standards. Some rely on the stricter McNaughton-type rule, and some include the newer American Law Institute's Model Penal Code. A few states like Idaho, Montana, and Utah have essentially abolished the traditional insanity defense altogether and replaced it with other ways of considering mental illness. They consider it just at the time of sentencing, not necessarily in whether determining someone is guilty or not guilty. At the federal level, after major reforms in the 80s, the law requires proof of a severe mental illness or defect and focuses again on whether the defendant could appreciate the nature and wrongfulness of their actions. So that's the legal framework. But how does it actually work in practice? So forensic psychologists and psychiatrists play the central role. Their job is not to decide whether the defendant is guilty or innocent, but to assess their mental state at the time of the defense or of the offense. They review the medical and criminal records, interview the defendant, administer psychological tests, and sometimes they speak with family members or other witnesses. Over time, structured instruments have been developed to bring more consistency to the evaluations, but there's still room for professional judgment and some disagreement among professionals. One big misconception is that defendants are constantly getting off on insanity pleas, but in reality, research from multiple states have shown that the insanity defense is raised in about 1% of felony cases, and only a fraction of those are successful. So it is very rare and a difficult defense. It's not a loophole that routinely sets dangerous people free. Real-world cases can help us see both the power and the controversy behind pleading guilty by reason of insanity. One famous example is John Hinckley Jr., who shot President Ronald Reagan in 1981. Hinckley was found not guilty by reason of insanity after evidence that he was severely mentally ill and driven by delusional thinking. The verdict led to intense public outrage. Many people believed he was getting away with it, even though he was committed to a secure psychiatric hospital for decades. Politically, the case triggered a wave of reforms. Congress and many states made insanity standards narrower. They shifted the burden of proof to defendants and limited the role of psychiatric experts. Another example is Andrea Yates, the Texas mother who in 2001 drowned her 5 children while suffering from severe postpartum psychosis. At her first trial, she was convicted of capital murder, but on her retrial, after psychiatric testimony, a jury found her not guilty by reason of insanity. She was not released, but instead she was committed to a state mental hospital where she remains under treatment to this day. Her case forced the public to confront how profound mental illness can completely distort a person's perception of reality and morality, especially in the context of motherhood. We also have cases where the insanity defense fails. Several. Several mass shooters, including the Aurora Theater gunman, have raised insanity defenses that juries have rejected. These outcomes show that even when a defendant clearly has a mental disorder, jurors are often skeptical that the illness has just erased their responsibility, especially in high-profile and emotionally charged cases. So these examples bring us to the ethical debates. On one side, there's a strong moral argument for the insanity defense. If someone, because of a severe mental disorder, cannot understand what they're doing or cannot appreciate that it's wrong, punishing them like a typical offender seems incompatible with basic notions of justice. The insanity defense reflects a commitment to treatment, such individuals as patients in need of treatment rather than as ordinary criminals. On the other side, there's more serious concerns. Some critics worry that the insanity defense undermines public safety or disrespects victims by appearing to excuse their acts. Others point to problems with the reliability of expert testimony, the difficulty of reconstructing a person's mental state at the time of the crime, and the risk of people exaggerating or faking symptoms to avoid punishment. There's also concerns about what happens after a verdict of not guilty by reason of insanity. In some jurisdictions, insanity quittees can be confined in secure hospitals for longer than they might have been imprisoned if they were simply convicted. That raises questions about due process, proportionality, and whether treatment-oriented institutions are sometimes being used as de facto prisons. A related ethical twist is the guilty by mentally ill verdict, which some states have adopted as a compromise. Juries who are uncomfortable with outright insanity acquittals can declare a defendant guilty but mentally ill, signaling that mental illness was present but not exculpatory. In practice, though, research suggests that these defendants often receive standard prison sentences and may or may not receive meaningful treatment. So, the guilty but mentally ill verdict can satisfy a desire for punishment without actually improving the care, and it further stigmatizes the mental illness. Finally, there are broader social justice issues. Access to high-quality forensic evaluations and expert witnesses is expensive. Defendants with resources may be better able to mount a credible insanity defense than defendants who come from a lower social status, even when their symptoms are similar. And cultural, racial, and gender biases can influence how behavior is interpreted, whether someone is seen as crazy or dangerous or simply evil. So, where does this leave us? The insanity defense is a small but symbolically powerful feature of criminal justice. It forces us to wrestle with core questions. What does it mean to choose? When does illness erase responsibility? How should we divide our responses between punishment, treatment, and protection of the community? During my research, I found 3 key things. First, insanity defenses are rare and hard to win, despite the public's beliefs that they are overused. Second, the criteria we use, like the McNaughton Rule and the Model Penal Code standard, are imperfect attempts to translate complex psychiatric realities into simple yes or no legal questions. And third, the way we treat mentally disordered offenders reflects our values as a society, whether we genuinely believe that mental illness can be so profoundly affect the mind that punishment alone no longer makes sense. As future professionals, voters, or even potential jurors, we are likely to encounter news stories and debates about these type of cases. My hope is that instead of reacting with reflex outrage and fear, we can approach them with a more informed, nuanced view, one that recognizes both the real dangers that some mentally ill offenders pose and the moral imperative to treat serious mental disorder as something more than just an excuse. Thank you.